Metal Bulb, second to Triple 5 of 2017.
Appellants are the original defendants. The plaintiff had filed the suit for their eviction on two grounds. One is defaulter of payment and another one is personal necessity. The suit was declared valid against the preferred appeal. The appeal was dismissed. Therefore, the present second appeal. The present second appeal is admitted for on the following substantial question of law. That is, they claim. Plaintiff claim. We are not claiming that we are the tenant. We claim our independent title over the property.
As per the plaintiff.
As per the plaintiff.
Read order dated 21/6.
21/6. Heard learned counsel for the appellant are defendants. The plaintiff had filed eviction suit being eviction suit number 2 of 2011 for eviction of the defendants, which is a residential house on the ground of default and personal necessity. The court below has recorded the finding that the relationship of landlord and tenant exists between the defendant, and further there is a default in payment and also requirement of personal necessity has been held in favor of the plaintiff. Accordingly, order of eviction has been passed. Being agreed, the defendant has challenged the same in appeal being title appeal number so. The appellate court has also confirmed the finding recorded by the trial court. Accordingly, the appeal has been dismissed. Thus, there are concurrent findings of both the courts below. Learned counsel for the appellant has challenged the concurrent finding on the ground that same has been based upon inadmissible piece of evidence, ignoring the relevant piece of evidence. The relationship of landlord and tenant has been established on the ground of unregistered lease agreement, although the same can be used for collateral purpose, but the defendant has disputed the existence of the same. The said unregistered deed of lease has not been proved by any cogent evidence. The procedural evidence number 1, who have given the oral evidence regarding existence of the lease agreement, was 1 year old on the date of alleged lease agreement. Further, the court has shifted the onus upon the defendant that they were supposed to prove the signature on the lease agreement that the same was not genuine. Both the court committed grave mistake by shifting onus, and on that basis, finding has been recorded regarding existence of relationship of landlord and tenant. In view of factual background, learned counsel for the appellant proposes the following substantial question of law, which is being accepted by this court, whether the genuineness, correctness, and existence and execution of unregistered lease deed dated 8/9/1989, which was proved by PW3 Binod Mandal, advocate clerk, is doubtful and questionable, and therefore the judgment and decree of eviction passed by both the learned court below is unsustainable in the eye of law. Whether the learned lower appellate court has gravely erred in law by shifting the onus of proving the unregistered deed of lease dated 8/9/1989 upon the defendant, which is contrary to the well-settled proposition of law that the plaintiff has to stand on his own legs and he cannot derive any benefit from the weakness of the defendant's case. Now, my lord, fact of this case, that the plaintiff has filed the suit on the basis that the said land belongs to Karu Mandal in record of rights. Karu Mandal is succeeded by Jagannath Mandal. It is stated that the Jagannath Mandal entered in an agreement in the year 1989, and thereafter the suit property was given on tenancy to the present defendants. They have not brought except that lease deed, that is for 11 years, and it is alleged in the said lease deed that 11,000 rupees as advance was paid by the defendant. No rent receipt, nothing was produced. And thereafter, their further allegation is since 2000 we paid the rent of 250. Thereafter, as we requested them to adjust the 11,000 advance, the same was adjusted, and so thereafter since 2004 we are paying 250. But after the death of original tenant, the defendants have not paid any amount to the plaintiff, and therefore the suit was brought. The personal necessity was also pleaded. Now, my lord, this exhibit, lease deed, which is exhibit 1, that is the main document. The same was proved by PW3. If my lord may permit, I may I may place the deposition of PW3 matters. Got it. मैं विनोद मंडल पिता नारायण मंडल उम्र 40 पेशा अधिवक्ता साकी पांडुडी थाना जसीडी जिला देवघर का शपथ पूर्वक बयान करता हूँ. My lord, his statement was recorded on 9/9/2012. At that time, he says that he was 40 years old. Therefore, at the time of execution of this deed, he must be of 17 years.
40 years.
हाँ, 2012 में बोल रहा है. 1989 का लीज डीड है. 1989. तो 11 साल उधर, 12 साल इधर, तो 23 साल हो गया. मैं इस मुकदमे में दोनों पक्ष को जानता हूँ. दिनांक 8/9/89 को एक लीज दलील बना था, जिसमें लीजदार के रूप में जगन्नाथ मंडल थे तथा लीज ग्रहीता के रूप में परमानंद शर्मा थे. दिनांक 8/9/89 को लीजदार के अधिवक्ता श्री बालेश्वर मंडल स्वयं लिखा तथा लिखने के पश्चात टाइपिस्ट श्री चंद्रकांत झा ने उसको टंकित किया. तत्पश्चात अधिवक्ता श्री बालेश्वर मंडल ने वह पक्षों को पढ़कर सुना व समझा दिया. तत्पश्चात सही पाकर वह पक्षों ने लीज डीड पर हर पृष्ठ पर अपना अपना हस्ताक्षर किया, जो मैं पहचानता हूँ. तत्पश्चात लीज डीड के हर पृष्ठ पर लघु हस्ताक्षर, साथ ही अंतिम पृष्ठ पर अपना हस्ताक्षर किया. साथ ही गवाहन तौर पर कारू मलिक ने अपना टिप्पा दिया, जिसकी पहचान अधिवक्ता बालेश्वर मंडल ने किया, एवं गणेश शर्मा ने भी अपने हस्ताक्षर किया, एवं टाइपिस्ट के रूप में चंद्रकांत झा ने भी अपना हस्ताक्षर डीड के अंतिम पृष्ठ पर किया, जो मैं बताता हूँ. तत्पश्चात उक्त लीज डीड 8/9/89 को नोटरी साहब श्री केवल प्रसाद सिंह नोटराइज किया, जो पहचानता हूँ, एवं हर पृष्ठ पर अपना सील मुहर के साथ नोटराइज किया, जो मैं पहचानता हूँ. तत्पश्चात लीज डीड के प्रथम पृष्ठ के पिछले पन्ने पर उभय पक्षों ने अपना टिप्पा दिया, जिसकी पहचान अधिवक्ता बालेश्वर मंडल ने की है, जो मेरी ही समझ की है. साथ ही नोटरी साहब ने भी उसको प्रमाणित किया, जो मैं जानता हूँ. इस लीज की सारी कार्रवाई मेरे द्वारा कराई गई. दिस इज इम्पोर्टेंट. वो कहते हैं कि लीज डीड की सारी कार्रवाई मेरे द्वारा कराई गई है. उक्त लीज डीड दिनांक 8/9/89 को संपूर्ण पदार्थ एक चिन्हित किया गया. क्रॉस एग्जामिनेशन. पारा 2 माइनस. आई एम जस्ट प्लेसिंग माय 2. मैं रविंद्रनाथ का, अच्छा नहीं, पूरा ही पढ़ देता है. प्रतिवादी की ओर से प्रतिपक्ष, मैं केवल वादीगण का वंश वृक्ष का समझा हूँ, प्रतिवादीगण का नहीं कह सकता हूँ. मैं 18 साल से अधिवक्ता लिपिक हूँ, फॉर 18 ईयर्स. और ये कह रहा है कि 89 का लीज डीड इन्होंने पूरी तरह से कराया है, उम्र 40 वर्ष. मैं रविंद्रनाथ का अधिवक्ता लिपिक हूँ. रविंद्रनाथ 9/3/94 से वकालत कर रहे हैं. मैं केवल दो ही मौजा को जानता हूँ, दोनों मौजा का जमाबंदी नंबर नहीं कह सकता हूँ. केवल कारू मंडल के नाम से खतियान है. खतियानी रैयत का बाप का नाम नहीं कह सकता हूँ. कारू मंडल को 2 बेटा एवं 4 लड़की है. चारों लड़की का नाम एवं पति का नाम तथा ससुराल कहाँ है नहीं कह सकता हूँ. दोनों मौजा में कुल मिला के कुल कितना जमीन है, उसका रकबा तथा निशान दाग है, वह भी नहीं कह सकता हूँ. मौजा बैजनाथपुर एवं रायगढ़ में मेरा घर द्वार नगर जमीन नहीं है. ऑन दैट मौजा. नौ para 6 मंडल। जगन्नाथ मंडल एवं परमानंद शर्मा कितने दूर तक पढ़े लिखे हैं मुझे मालूम नहीं है। जगन्नाथ शर्मा का दूसरे केस का पैरवी अधिवक्ता लिपिक के रूप में परमानंद अधिवक्ता रूप में हम पैरवी नहीं किए हैं। परमानंद शर्मा को पहले से नहीं जानते थे। परमानंद शर्मा कब और उसका दिन महीना साल नहीं कह सकते हैं। लीज डील होने के 4-5 साल बाद परमानंद शर्मा का मृत्यु हुई, जबकि it has come on record that he died in the year 2010. बालेश्वर मंडल का अधिवक्ता लिपिक विश्वनाथ दास लगभग 30 वर्ष पूर्व से है तथा उसको बालेश्वर मंडल का भी लिपिक है, अधिवक्ता लिपिक है। केवल सिंह अधिवक्ता अभी भी नोटरी का काम करते हैं। So this is the person, my lord, who has notarized the said agreement. He is alive and he is present. 6 persons have signed the said agreement, but none of them has come forward to prove the same. और अभी भी नोटरी का काम करते हैं। नोटरी रजिस्टर का नंबर 835 पर उतारा गया है। उपरोक्त लीज डीड में गवाह के रूप में मेरा कोई हस्ताक्षर नहीं है। लीज डीड का स्थान को खरीदा एवं किसने नाम से खरीदा था मुझे मालूम नहीं। लीज डीड का स्टाम्प किसने खरीदा और किसके नाम से खरीदा मुझे मालूम नहीं है। कितना रुपया का स्टाम्प था मुझे मालूम नहीं है। शिव नारायण रवानी स्टाम्प वेंडर से खरीदे थे। लीज डीड के कितना रोज पहले खरीदे थे मुझे मालूम नहीं है। ऐसी बात नहीं है। Now it denies. So my lord, this person has come to prove a deed which is allegedly
He has stated that in his presence the deed was signed. इसमें कोई cross examination का एक भी representation है ना cross examination।
इस पॉइंट पर नहीं है कि जो फोर्स्ड है, बट ये पॉइंट आया है कि एट दैट रिलेवेंट टाइम ही वाज 17 इयर्स
इससे
ओल्ड।
क्या मतलब?
वो दूसरे अधिवक्ता का लिपिक है।
इससे क्या मतलब? 17 साल का लड़का बच्चा इनकॉम्पिटेंट है।
तो आई एम नॉट टॉकिंग अबाउट द
आप देखिए,
इनकॉम्पिटेंसी।
आप जिस आदमी ने लीज डीड एग्जीक्यूट किया है, बोल रहा है मेरे सामने साइन किया है, उसमें कोई क्रॉस एग्जामिनेशन नहीं है।
हाँ, नहीं है, लेकिन मैं हम्बल सबमिशन
अगर मान लीजिए कोई अनरजिस्टर्ड लीज डीड आता है आपके पास, which is of 11 years, क्या होगा? मैक्सिमम इट्स अ मल्टीपल टेनेंसी।
तो
लीज का टर्म्स एंड कंडीशंस नहीं मान्य होगा।
मैंने हमारा द केस ऑफ द डिफेंडेंट इज दैट कारू मंडल हैज सेटल।
नहीं, पहला इस गवाह पर है, इस गवाह का काम है।
तो हमारा इस गवाह
कोई
पर
क्रॉस एग्जामिनेशन नहीं है ऑन द पॉइंट ऑफ सिग्नेचर। करेक्ट? वी हैव रेड द एंटायर क्रॉस एग्जामिनेशन।
उस पर नहीं है।
तो इसके गवाही पर आपको दो चीज बोलना है। TW 3 advocate clerk.
He goes down minus 9/2012
9/9/2012, right?
months.
Claiming that he was 40 years. His deed is dated
This dated 8/9/1989.
8/9/1989,
Months.
and therefore on 8/9/1989 you have recognized
उनका एज 17 साल होगा। 23-18 के 17 होगा। फर्दर वो कहते हैं कि हम 16 साल से यूपी का काम कर रहे हैं।
1989 में अगर 17 साल जोड़ेंगे तो कितना होगा?
अगर जो 2012
जरा ठीक से कैलकुलेट करिए। 23 साल उसका होगा। हमसे कैलकुलेशन मिस्टेक हो सकता है।
एक मिनट में देखा जाए। 8 9 80 उधर से 11 साल हो गया, 12 को डिपोज किया है तो 23 साल। हाँ वही तो कह रहे हैं, जो 23 साल का वो हुआ, 23 साल पीरियड को हम डिवाइड किए 40 में, तो एट दैट इन 1989 ही वाज 17, तभी
तो वो मतलब 1989 में वो कितने साल का होगा?
17 साल में अगर 23 ऐड करेंगे तो 2012 है। यस, एंड ही इज सेइंग कि 16 साल से वो कर रहा है। हाँ, माइनर से हमारा नहीं करना है, जो हमारा कहना है कि ही इज डिपोजिंग सो फार एज कि ये डीड उसके सामने ही सब काम हुआ, सब आदमी ने सिग्नेचर किया, एवरीथिंग इज सेम। वो खूब आदमी ही खुद कोर्ट में 16 साल से आ रहा है, 23 साल पहले का एक डीड को प्रूफ कर रहा है। उसके बाद वो खुद कह रहा है कि जो नोटरी है उस वक्त के, वो नोटरी भी वहाँ प्रेजेंट है, बट दैट नोटरी वाज नॉट ब्रॉट।
नो क्रॉस एग्जामिनेशन ऑन दिस पॉइंट।
हाँ, ये इस पॉइंट पे कि आपने नहीं देखा है ऐसा कुछ नहीं है। अब अगर सजेशन लास्ट लाइन में कुछ दिए हो तो देख लेना। सजेशन में ये लिखा है, ऐसी बात नहीं है कि मैंने के रूप से प्रभावित होकर गलत बयान दिया है एवं गलत पहचान किया है। ऐसी बात नहीं है कि लीज डीड का गलत पहचान। मेरा कहना है कि देयर वर 5 पर्सन्स executed murder, 2 witnesses, 1 advocate। लीज डीड में 5 आदमी का सिग्नेचर है, वो भी हम दिखा दे रहे हैं।
5 persons है,
2 विटनेस है, 2 एग्जीक्यूटेड है, 1 आइडेंटिफायर, 6-7 है।
executors, 2 witnesses,
हाँ।
और आगे
2 witnesses, 1 person who typed the lease deed, he has also put his signature।
5 हो गए।
छठा हो गया जो आइडेंटिफाई
5 persons बोले ना।
हाँ वो गलती हो गई। छठा एक एडवोकेट है जिन्होंने आइडेंटिफाई किया दोनों को, और 7वां है जो
एक ही एडवोकेट ने दोनों को आइडेंटिफाई किया।
हाँ, और 7वां है जो कि आपका नोटरी पब्लिक है। और ये विटनेस कम से कम इतना तो बोल रहा है कि नोटरी पब्लिक अलाइव है, आज भी नोटरी है। तो जस्ट टू प्रूव एन इनएडमिसिबल डॉक्यूमेंट दे हैव ब्रॉट अ विटनेस जो कि ये नहीं बता पा रहा है कि भाई आखिर इसको इस लीड से कहाँ जानकारी है, वो दोनों पक्ष को नहीं जानता। हाँ तो
दोनों विटनेस
उसका नहीं पता है। हम खाली ये बता रहे हैं कि वो जो केवल सिंह जो है, जो नोटरी है, वो जिंदा है, वो ये विटनेस बोल रहा है। बाकी और इसका कुछ नहीं आया है कि प्लेंटिफ ने कहा कि भाई ये लोग नहीं है, देयरफॉर दे आर नॉट बीइंग ब्रॉट।
अब इम्प्यूट जजमेंट में हो गया, इससे ज्यादा गवाही नहीं देंगे।
हाँ
सेकंड अपील में इससे ज्यादा नहीं देंगे।
नहीं बस इतना दिखा
देखेंगे एग्जिबिट 1।
हाँ एग्जिबिट 1
ये रख प्लीज।
अब हम पहले ट्रायल कोर्ट का जजमेंट पढ़ देते हैं।
पहले 20 दिन
हाँ लीज डीड वही तो दिखा रहा है, वही तो हाँ, नहीं इसमें डिफेंडेंट का केस भी है सर। देखा जाए एग्जिबिट टू, उसका इंस्टीट्यूशन पार्ट पर आते हैं।
It was marked without objection.
ऑब्जेक्शन तो मेरे हिसाब से नहीं सर।
There is no objection. Marked without objection.
लेकिन उसमें जो इनका WS है उस हिसाब से तो आना चाहिए था, आप काहे नहीं मान रहे?
Document exhibited without objection. ये नोटिस किया था खाली करने के लिए,
हाँ,
इसका कोई रिस्पांस दिया क्या?
हाँ नहीं इसका कोई हम रिस्पॉन्स नहीं दिए थे ना। उसमें जो दो डॉक्यूमेंट है हमारे तरफ से जो प्रोड्यूस हुआ है, वन खुरपानामा ऑफ द ईयर 1936 वेयर बाय कारू मंडल हैज सेटल्ड द said land and gifted the said land to these defendants, and my lord one
Gifted.
खुरपानामा
कृपा हो तो सेटल किया गया
that is the mode of settlement prior to
but in
community.
said Kurfadama there is no boundary.
आप बैठे You came on the basis of Kurfana.
खुरपानामा
और बाकी आगे
settled. Thereafter, my lord, in the year 2010, certain dispute has arisen with regard to boundary. So this Jagannath Mandal has executed an affidavit stating that his father has settled the said land to us, and as because we have settled the boundary, and therefore he has only shown an affidavit to that effect ki that now nothing, there is no dispute in between the parties.
It was exhibit number.
Yes. Exhibit C.
this Jagannath Mandal is the plaintiff.
No, is a person who has entered in an agreement. लीज डेट में जो हुआ है, हाँ, ये प्लेंटिफ के एसेसर।
Plaintiff के ancestor. और उसके लीज डीड में ताराचंद शर्मा है.
हाँ, ये खुरपानामा।
खुरपानामा किसके नाम से?
खुरपानामा मेरे एसेसर के।
और क्या नाम है आपके ancestor?
वही ताराचंद शर्मा। ताराचंद शर्मा। इस एफिडेविट में ये एडमिट करते थे और फिर 1992 में हमारा म्यूटेशन भी हो जाता है। नाउ दे आर ब्रिंगिंग दिस सूट।
म्यूटेशन किसके नाम से है?
म्यूटेशन भी मेरे नाम से है। म्यूटेशन का ऑर्डर लगा है।
म्यूटेशन का रेट रिसीव कई लोगों ने फाइल किया.
नहीं, वो अपने वो कारू मंडल के, चूंकि इनका बड़ा खाता है, अभी मात्र 3 डिसमिल का झगड़ा है। जो ये है इसका हम तो देते हैं एग्जीक्यूटिव डी। तो उसका रिसीट एग्जीक्यूटिव है। हाँ,
खुरपानामा आपका 36
खुरपानामा 36 में एफिडेविट
से
से
92 तक.
उसका बीच में कुछ नहीं। 90 में ये एफिडेविट किए। एफिडेविट के आधार पर हम एसडीओ क्या मूव किए कि भाई जो है इन्होंने खुरपानामा से सेटल किया।
एफिडेविट के आधार पर आपके नाम से जमा कर दिया.
हाँ
खुरपानामा के बाद 36 में खुरपानामा
जी।
एक बी रजिस्टर करना है.
नहीं,
पहला आपका रजिस्टर बनना है 92.
और उसके 20 साल के बाद ये सूट लाया जा रहा है।
आगे बढ़िए. इम्प्रूव जजमेंट करते हैं.
फाइंडिंग्स
कॉन्फिडेंट फाइंडिंग में तो आपके कोर्ट का जजमेंट का डिसीजन हो जाएगा.
वो नीचे कोर्ट में जो 2 पेज है, तो अगर नीचे कोर्ट से ही पढ़ देते।
आपको जहाँ समझ में कॉन्फिडेंट फाइंडिंग में तो कोई फर्क नहीं है.
हाँ, तो उसको भी हम खाली प्लेस कर देते हैं, छोटा सा। इंटरनल पेज 13 से पढ़ रहा है, जहाँ से कोर्ट का फाइनल है।
इश्यूज कौन से किया?
ये इशू है इंटरनल पेज 4। क्या वादी का यथा विचार विरचितवाद संधार्य है? क्या वादी को वर्तमानवाद के लिए वैध वाद हेतु प्राप्त है? क्या वादी और प्रतिवादी के बीच में मकान मालिक एवं किराएदार का संबंध है? क्या प्रतिवादी झारखंड भवन पट्टा किराया एवं बेदखली नियंत्रण अधिनियम के उपबंधों के तहत किराया भुगतान के मामले में व्यतिक्रमी है? क्या वादी को वाद परिसर की युक्ति युक्त सद्भावपूर्ण आवश्यकता अपने उपभोग के लिए है? क्या वादी को युक्ति युक्त सद्भावनापूर्ण आवश्यकता वाद परिसर को आंशिक रूप से खाली होने से पूर्ण हो जाएगी। क्या वादी प्रतिवादी 2500 प्रतिवादी से 2500 रुपया बकाया किराया प्राप्त करने का हकदार है? क्या वादी याचित अनुतोष का हकदार है? दीज आर द इश्यूज। फाइंडिंग पेज 13 से पढ़। उभय पक्षों के विद्वान अधिवक्ता का बहस सुना, अभिलेख पर उपलब्ध साक्ष्यों सामग्रियों का अवलोकन किया। वादीगण का दावा है कि वाद परिसर 250 रुपये प्रति माह की दर से 11 वर्षों के लिए दिनांक 8/9/89 को जगन्नाथ मंडल ने परमानंद शर्मा को किराए पर दिए थे, जिसके लिए दयानंद शर्मा ने दिनांक 8/9/89 को एक लीज डीड निष्पादित किए। अपने इस दावे को साबित करने
दयानंद शर्मा भी कहाँ से आए?
दयानंद शर्मा फादर ऑफ
किंतु जगन्नाथ मंडल ने परमानंद शर्मा को किराए पर दिया।
हाँ,
दयानंद शर्मा कहाँ से आए?
गलती से दयानंद शर्मा इसका नाम है जगन्नाथ मंडल और परमानंद शर्मा के बीच में हुआ। ये दयानंद शर्मा लगता है मिस्टेक है, क्योंकि वो एक्सक्यूटर का नाम लिख रहा है। दयानंद शर्मा ने दिनांक 8/9/89 को एक लीज डीड निष्पादित किया। अपने इस दावे को साबित करने हेतु वादीगण की तरफ से दिनांक 8/8/89 का लीज डीड प्रदर्श एक प्रमाणित करा गया। उक्त लीज डीड निबंधित नहीं है। उक्त लीज डीड पर उभय पक्षों का हस्ताक्षर जिनके 50 सिविल कोर्ट देवघर के अधिवक्ता द्वारा की गई है। उक्त लीज डीड वाद परिसर के संबंध में जगन्नाथ मंडल एवं परमानंद शर्मा द्वारा साक्ष्यों की उपस्थिति में निष्पादित किया गया, जिसमें पट्टाकर्ता जगन्नाथ मंडल और पट्टाधारी परमानंद शर्मा। उक्त लीज डीड में वाद परिसर को जगन्नाथ मंडल द्वारा परमानंद शर्मा को 250 रुपये प्रति माह के किराए पर 11 वर्षों के लिए देने की बात कही गई है, जिसे परमानंद शर्मा द्वारा स्वीकृत भी किया गया है। उक्त लीज डीड में कई शर्तें वर्णित हैं, यद्यपि कि उक्त लीज डीड निबंधित नहीं है और संपत्ति अंतरण अधिनियम की धारा 107 के अनुसार उक्त तरह का लीज डीड निबंधित होना आवश्यक है। इस प्रकार उक्त लीज डीड साक्ष्य में ग्राह्य नहीं है। लेकिन न्यायिक निर्णयों से यह स्थापित हो चुका है कि गैर रजिस्ट्रीकृत पट्टे का उपयोग अनुषंगी उद्देश्यों के लिए किया जा सकता है। इसका प्रयोग भारतीय रजिस्ट्रीकरण अधिनियम की धारा 49 के प्रस्तुत में दिए गए उद्देश्यों के लिए भी किया जा सकता है। इसका उपयोग संविदा के साक्ष्य के रूप में या एक अनुषंगी समव्यवहार जिसका रजिस्ट्रीकरण आवश्यक नहीं है के साक्ष्य के रूप में किया जा सकता है। इस प्रकार उक्त लीज डीड को इकरारनामा के रूप में व्यवहार में लाया जा सकता है, जिसके अवलोकन से यह स्पष्ट होता है कि वादीगण के पिता जगन्नाथ मंडल वाद परिसर के मकान मालिक थे और परमानंद शर्मा किराएदार थे। उधर 4 से यह साबित होता है कि जमाबंदी नंबर 142 के खजानी रियत कानून मंडल है, जो वादीगण के पूर्वज है। इस तथ्य को प्रतिवादीगण द्वारा भी स्वीकृत किया गया है। दूसरी तरफ प्रतिवादीगण का दावा है कि प्रतिवादीगण तथा उनके पूर्वज वाद परिसर के कभी किराएदार नहीं थे और उभय पक्षों के बीच मकान मालिक किराएदार का संबंध नहीं है। प्रतिवादीगण 1936 से वाद परिसर पर काबिज है और उसके मालिक है, और वादीगण का लीज डीड एक जाली एवं बनावटी दस्तावेज है और वादीगण किराएदारी के संबंध में कोई कागज दाखिल नहीं किए हैं। प्रतिवादीगण की तरफ से प्रमाणित कराया गया दस्तावेज प्रदर्श बी दिनांक 6/2/36 का कुप्पानामा एवं प्रदर्श सी कुप्पानामा के समर्थन में जगन्नाथ मंडल का शपथ पत्र एवं प्रदर्श डी वाद परिसर से संबंध में दाखिल खारिज आदेश और इन्हीं दस्तावेजों साक्ष्यों पर प्रतिवादीगण द्वारा यह वाद परिसर का अपने को मालिक बताया गया है, जबकि उक्त दस्तावेजों के आधार पर स्वामित्व का निर्धारण नहीं किया जा सकता है। वैसे भी इस वाद में किसी भी पक्षकार के स्वामित्व का निर्धारण नहीं करना है, बल्कि न्यायालय को यह देखना है कि उभय पक्षों के बीच मकान मालिक और किराएदार का संबंध है या नहीं। प्रतिवादीगण द्वारा लीज डीड प्रदर्शन को जाली एवं बनावटी बताया गया है, इसलिए इस तथ्य को साबित करने का भार प्रतिवादीगण पर है। Now the onus has been shifted. प्रतिवादी साक्षी संख्या 4 नीरा देवी, जो स्वर्गीय परमानंद शर्मा की पत्नी है, ने मुख्य परीक्षण के पैरा 8 में कहा है कि परमानंद शर्मा बराबर अपना हस्ताक्षर अंग्रेजी में किया करते थे। बैंक का पासबुक तथा अन्य दस्तावेज आदि परमानंद शर्मा बराबर अपना हस्ताक्षर अंग्रेजी में करते थे, लेकिन प्रतिवादीगण की तरफ से ऐसा कोई दस्तावेज साबित नहीं कराया गया है जिस पर परमानंद शर्मा का हस्ताक्षर हिंदी या अंग्रेजी में हो। प्रतिवादीगण द्वारा कथित लीज डीड को जाली साबित करने का प्रयास भी नहीं किया गया है। प्रत्येक पक्षकार को अपने कथन को सबूत द्वारा साबित करने की आवश्यकता होती है। प्रतिवादीगण अपने मौखिक एवं दस्तावेजी साक्ष्यों से कथित लीज को जाली साबित करने में विफल रहे हैं। प्रतिवादीगण के विद्वान अभियुक्तों का यह भी कहना है कि वादीगण द्वारा किराया का एक भी रसीद दाखिल नहीं किया गया है। इस संबंध में मैं पाता हूँ कि वादीगण द्वारा किराया का एक भी रसीद प्रस्तुत नहीं किया गया है, लेकिन मकान मालिक एवं किराएदार के बीच का संबंध विश्वास पर आधारित होता है। किराएदार सामान्यतः किराया भुगतान के लिए रसीद मांगने हेतु अपेक्षित नहीं है जब तक इस संबंध में कोई विशेष संविदा न हो। प्रतिवादीगण का यह भी दावा है कि एसपीटी एक्ट की धारा 20 के अनुसार रैयत के अधिकार का अंतरण लीज डीड वगैरह से नहीं हो सकता है और वादीगण का वाद बीबीसी एक्ट के अंतर्गत पोषणीय नहीं है। यद्यपि एसपीटी एक्ट की धारा 20 के अनुसार रैयत के अधिकार का अंतरण लीज वगैरह से नहीं किया जा सकता है, लेकिन यह विषय वस्तु इस बात का नहीं है। इस बात संपत्ति हस्तांतरण की कोई बात नहीं है। इस बात में सिर्फ वाद परिसर को वादीगण के पिता द्वारा प्रतिवादीगण के पूर्वज परमानंद शर्मा के किराए पर देने की बात की है, जिसे संपत्ति का हस्तांतरण नहीं कहा जा सकता है। बीबीसी एक्ट संपूर्ण बिहार झारखंड राज्य के भवन संबंध में प्रभावी है, इसलिए वादीगण का वाद बीबीसी एक्ट के अंतर्गत प्रति है। वाद पत्र के अवलोकन से यह स्पष्ट है कि जगन्नाथ मंडल के कुल 6 लड़के हैं। वादी साक्षी संख्या 6 विकी कुमार मंडल, जो जगन्नाथ मंडल के पुत्र हैं, ने अपने परिसाक्ष्य में अपने दावे को साबित किया है और बताया कि प्रतिवादीगण जुलाई 2010 से किराया देना बंद कर दिया है। हम लोग का परिवार बढ़ गया है, सभी भाइयों की शादी हो गई, बच्चे बड़े हो गए, इसलिए इस बात परिसर की आवश्यकता है। वादी साक्षी संख्या 6 के दावे और साक्ष्य का समर्थन एवं संपुष्टि वादीगण की तरफ से परीक्षित कराए गए अन्य साक्ष्यों के साक्ष्य होता है। दूसरी तरफ प्रतिवादीगण की तरफ से परीक्षित कराए गए मौखिक साक्षी भी प्रतिवादीगण के दावे का समर्थन किया है, लेकिन दावा सिर्फ मौखिक है। प्रतिवादीगण की तरफ से अपने दावे के समर्थन में कोई सारभूत दस्तावेजी साक्ष्य प्रस्तुत नहीं किया गया। प्रतिवादीगण की तरफ से 1936 से 1949 के पूर्व अथवा 1990 के पूर्व तक का कोई कागज दाखिल नहीं किया गया है। और प्रतिवादी साक्षी संख्या 5 भैरव प्रसाद लाल, जो प्रतिवादीगण के कृपानामा को साबित किए हैं, ने अपने मुख्य परीक्षण की पैरा 3 में स्पष्ट रूप से कहा है कि ताराचंद कुमार मौजा बैजनाथपुर थाना देवघर जिला संथाल परगना को मैं जानता हूँ, जिनके बैजनाथपुर स्थित भाड़े के मकान में मेरा आना जाना होता है। इन्होंने प्रति परीक्षण की पैरा 14 में कहा है कि विवादित संपत्ति के पूर्व मालिक कारू मंडल थे। इस प्रकार प्रतिवादीगण के साक्षी
आपकी का एविडेंस आपके खिलाफ
ये कह रहा है जो कि
आपका गवाही आपके खिलाफ यही ना बोलते हैं।
नहीं, वो कह रहे हैं कि वो एक दूसरा मकान भी है जिसमें कि वो किराए पर रहते हैं।
आपकी की तरफ से नहीं आए।
हाँ, ये मेरे तरफ से आए थे।
तो इन्होंने ही आपके खिलाफ।
तो ये दुकान है जहाँ हम काम करते हैं। ये कह रहे हैं कि हम एक मकान में जो किराए पर रहते हैं और वहाँ पर आते जाते हैं, भाड़े पर मेरा आना जाता है। इस प्रति परीक्षा की पैरा 14 में कहा कि विवादित संपत्ति का पूर्व मालिक कारू मंडल थे। इस प्रकार प्रतिवादीगण के साक्षी के परिसाक्ष्य से यह स्पष्ट होता है कि प्रतिवादीगण के पूर्वज वहाँ भाड़े पर थे। इस प्रकार उभय पक्ष द्वारा प्रस्तुत किए गए मौखिक दस्तावेज एवं साक्ष्य सामग्री उभय पक्ष के विद्वान अभियुक्ता को सुनने तथा सभी तथ्यों की परिस्थिति विचार करने के उपरांत इस निष्कर्ष पर वादीगण का मौका था। सो दिस इज द फाइंडिंग ऑफ द ट्रायल। अब अपने ऊपर कर देते हैं। फाइंडिंग इसका स्टार्ट हो रहा है पेज 6 से। It is the case of the plaintiff responded that they are the owner and landlords of the suit premises and the appellant defendants were their tenants. The suit premises was let out by the Jagannath Mandal in favor of Parmanand Sharma on 8/9/1989 for a period of 11 years by executing an unregistered deed of lease. The rate of monthly rent was fixed at rupees 250. Parmanand Sharma had also given 11,000 in advance to Jagannath Mandal. Parmanand Sharma paid monthly rent in hand to Jagannath Mandal till August 2000, and then the advance money was adjusted in monthly rent till April 2004. Thereafter, the appellant continued to pay rent to the respondent till June 2010 at the rate of 250 per month. However, after the death of Parmanand Sharma in June 2010, the appellant stopped paying rent to the respondents. In order to prove this fact, the plaintiff respondent have proved the unregistered lease deed dated 8989. On careful perusal of the lease deed, it appears that it was prepared on a stamp paper before a notary, and it bears the signature of both Jagannath Mandala as the lessor and Parmanand Sharma as the lessee. It also bears the thumb impression of Karun Ali and signature of Ganesh Sharma as witness. The aforesaid lease deed was prepared by Baleshwar Mandal, advocate, and typed by Chandrakant Jha. The signature of Jagannath Mandal and Parmanand Sharma have also been identified by advocate Baleshwar Mandal. It is clear from the lease deed that the suit premises was let out by the lesser Jagannath Mandal.
You are claiming that the signature of your predecessor in that
Yes.
or predecessor is forged.
Yes.
So, and he has expired.
Yes.
The wife comes and divorces that he used to sign in DUD.
Yes. Yes.
No document was produced in connection with his signature. And if a person has to examine the signature, then he has to produce his admitted signature.
This is मतलब
कौन produce करेगा?
ये तो ये प्लेंटिफ का था क्या?
प्लेंटिफ कहाँ से produce करेगा?
नहीं प्लेंटिफ कोर्ट को बोलेगा प्रोड्यूस तो हम करेंगे बिकॉज़
necessary है ना?
मेरा कहना है वो डॉक्यूमेंट हमारे
admitted signature का आपको produce
हाँ मेरे तो अगर हमको कोर्ट कहती कि इनका कंपैरिजन
ये इनका सिग्नेचर है, ये इस तरह से साइन नहीं करते थे, ये इनका सिग्नेचर है, कहाँ प्रोड्यूस?
वो हम प्रोड्यूस नहीं कीजिए, बट इट इज द मेरा कहना है कि ओनस इज अपॉन द प्लेंटिफ टू प्रूव that his signature is genuine, and in that connection he may pray before the court for producing the admitted document wherein the signature of Parmanand Sharma is there, and thereafter the same may be sent to FSL for the examination. This onus has been shifted to me. This is the second substantial question of law malice.
Onus is always on the person who alleges. When you say that it is fraudulent, when you say it is forged, then it was your duty to produce the admitted signatures. मान लीजिए कोई registered sale deed में कोई signature है, या मान लीजिए कोई ऐसा document में कोई signature है, ये आपकी duty थी produce करने की, so that the appropriate steps would have been taken for examination by your handwriting expert.
Steps. This is my submission. Malice. The steps has to be taken by the plaintiff.
That's all. क्या बोलना है आपको?
इसमें तो खाली हम जजमेंट देना चाह रहे हैं। ये है कोलेटरल पर्पस के लिए जो सेक्शन 49 को बोल रहा है। बस
What is the description of the property? ठीक
ये डिग्री में दिया हुआ है जैसे ट्रायल कोर्ट का डिग्री में शेड्यूल में दिया हुआ है
ठीक
वन रूम है
चलिए जजमेंट
जजमेंट है अगर कोलेटरल पॉइंट पे इसमें भी एक लीज डीड था जो कि उसमें क्लाउज डी था कि दैट इज दिस दैट लीज डीड हैज बीन एक्सक्यूटेड ओनली फॉर दैट पर्पस now the said deed was found not admissible in evidence. Now it was considered what is the what collateral means. If for all practical purposes the lease deed will be relied upon and gone into, then collateral means what? And thereafter the Honorable Supreme Court has said the provision which says that this house will the lease will sustain only to the point that a particular officer will hold the house cannot be read in evidence. And accordingly,
कौन सा बना है
हम पारा 22 onwards पढ़ लेते हैं.
फाइंडिंग पढ़िए ना सीधे
पारा 28 पढ़ लेते हैं. Having heard the learned counsel for the appellate year of review, the decision of this court in Vitika Malik case on which the strong reliance was placed by the learned counsel for the appellate is of no help to the appellate because rightly pointed out by the High Court that the same was based on registered deed of lease. In such and such case, as noted here in above, it has been held that language of section 13 of the Act makes it clear that one not standing anything to the contrary contained in any other law, an order or decree for a recovery of possession of any premises shall be made by the court in favor of the landlord against a tenant on the ground mentioned in that section. It was further observed that in view of the language of section 31 of the parties have freedom to contract out of the section. In the aforesaid judgment of this court, on which strong reliance was placed by the appellant, the fact was that the predecessor, in interest of the respondent, in that appeal leased out the premises in question in favor of one Lal Bihari Malik in a registered deed of lease at the monthly rental of ₹60, and the lease deed contained a covenant that the lease was for the lifetime of lessee, and his heirs, executor, administrator, representatives, and heirs must yield up and deliver quite peaceful and vacant possession of the devised premises within 3 months from the date of death of lessee unconditionally and without any objection whatsoever. It was further stipulated that they shall have no right to hand over the demised premises after the said period under any circumstances. The lessee died on 16 12 1970 and his heirs did not deliver the vacant position in favor of the lessor or their successor in interest, and this necessitated filing of the suit for eviction of the defendants. In that decision, the main defense raised by the raised in written statement was that the original lease, lessee Lal Bihari Malik having died on Itna, the registered lease deed dated Itna shall fall under the category of the West Bengal Premises Tenancy Act and the tenancy who are residing in the demised premises with the said lessee namely Lal Bihari Malik during his lifetime become monthly rental tenant under the plaintiff and of that case by operation of law. In view of the aforesaid fact and considering the fact that the aforesaid decision was now, as we have already noted, para 22, as we have already noted under the provision of section 49 of the Registration Act, an unregistered document can also be admitted into evidence for a collateral fact, collateral purpose. Let us now look at the meaning of collateral purpose and then ascertain whether clause 9 of the lease agreement can be looked into for such collateral purposes. In Haran Chandra versus so it was held that the terms of compulsory registrable instrument are nothing less than a transaction affecting the property comprised in it. It was also held that to use such an instrument for the purpose of proving such a term would not be using it for a collateral purpose, and that the question as to who is the tenant on what terms he shall be terms he has been created a tenant are not collateral facts, but they are important terms of the contract of tenancy which cannot be proved by admission of an unregistered lease deed into evidence. The High Court in the impugned judgment relied on the decision of the Allahabad High Court in so and so to hold that since the appellant wanted to extinguish the right of the respondent with the help of unregistered tenancy, the same was not a collateral purpose. In Ratanlal case, while discussing the meaning of the term collateral purpose, the High Court has observed as follows. The second contention was that the partition deed, even if it was not registered, could certainly be looked into for collateral purpose. But the collateral purpose has a limited scope and meaning. It cannot be used for the purpose of saying that the deed created or declared or assigned or limited or extinguished a right to immovable property. That collateral purpose would not permit the party to establish any of these acts from the deed. In Bajaj Auto Limited versus Bihari Lal Kohli, this court observed that if a document is inadmissible for non-registration, all its terms are inadmissible, including the one dealing with landlord's permission to his tenant to sublet. It was also held in that decision that if the decree purporting to create a lease is inadmissible in evidence for want of registration, हम बोलना चाह रहे हैं कि 1989 का लीज डेट है ट्रायल कोर्ट एज वेल एज द अपीलेट कोर्ट हैज हेल्ड कि इट इज इनएडमिसिबल और इन एविडेंस नाउ दे से कि but it can be used for collateral purpose. There is no other evidence.
They have not used it for collateral purpose. Rather, both the judgments are based on the evidence of DW5. Both the judgments are based on the evidence of DW5.
No, both the judgments are based on lease deed. DW5 अच्छा DW5 को
उसका कोई question of law नहीं करना.
नहीं उसका हम ध्यान नहीं.
There is a concurrent finding of both the courts that your witness has stated that it was a tenanted premises.
This was not, he was residing in some other
You
house.
do not know. That is not the question of law. That is not the question of law. There is a concurrent finding by both the courts
मेरा
on the
submission is
attestation of evidence of DW5.
only on the basis of lease deed both the courts has come to the conclusion that the defendants are tenant and therefore I
ट्रायल
am
कोर्ट का वो फाइंडिंग लिखा है ना. लीज डीड के बेसिस पर बोल दिए हैं कि आप जो है
lease deed की basis पे ना
कहाँ बोले
वही हम पढ़ रहे हैं. इंटरनल पेज 30
of the trial court.
of the trial court. हम ऊपर से 10-15 लाइन छूट के पढ़ रहे हैं. संपत्ति का अंतरण अधिनियम की धारा 107 के अनुसार उत्तर के लीज डीड निबंधित होना आवश्यक है. इस प्रकार लीज डीड साक्ष्य में ग्रहण नहीं, लेकिन न्यायिक निर्णयों से यह स्थापित हो चुका है कि गैर रजिस्ट्रीकृत पट्टे का उपयोग अनुषंगी उद्देश्यों के लिए किया जा सकता है. उसका प्रयोग भारतीय रजिस्ट्रेशन अधिनियम की धारा 49 की परंतु में दिए गए उद्देश्यों के लिए भी किया जा सकता है. उसका उपयोग संविदा के साक्ष्य के रूप में या एक अनुषंगी से व्यवहार जिसका रजिस्ट्रीकरण आवश्यक नहीं है के साक्ष्य के रूप में किया जा सकता है. इस प्रकार उपनिजी को इकरारनामा के रूप में व्यवहार में लाया जा सकता है, जिसके अवलोकन से स्पष्ट होता है कि वादीगण के पिता जगन्नाथ मंडल वाद परिसर के मकान मालिक थे और परमानंद शर्मा किराएदार थे. अब इसके बाद जो फाइंडिंग दे रहे हैं फाइंडिंग तो यही दे दिए.
So you want to say that it cannot even be looked into for the purposes of relationship of landlord.
My submission is if there are other documents showing something and this document if added, then the chain will be complete, then it is collateral purpose. But if the only this is the only document for ascertaining something, then it can't be relied by the court, and for this judgment only for that.
And what about the evidence of DW5?
DW5 का अगर जो है पढ़ दीजिएगा उसको,
नहीं, पढ़ने का
ये तो कोर्ट जो कोर्ट किया है आज उसकी बात हो रही है। अगर आप कहिए तो हम DW5 पढ़ देते हैं। उसका कहना है कि ये जो सूट प्रीमाइसेस है जो ये
उस पॉइंट पर कोई क्वेश्चन ऑफ लॉ नहीं बना है।
हम क्वेश्चन ऑफ लॉ पर जा रहे हैं। अब उसको अगर रिलाई किया वो परवर से हम उस पर भी जस्ट पासिंग रिमार्क्स ऑफ द कोर्ट हम कहेंगे। बट वो जो है जो वहाँ ये दुकान है, इस दुकान में ब्लैक स्मिथ का हम काम करते थे, हमको इसलिए खुरपानामा देकर दिया, लेकिन हम रहेंगे कहीं, तो वो मेरे घर आते जाते थे।
और ये जो 2010 में जो रेंट रिसीट इशू हुआ है काबू मंडल के नाम
2010
एग्जिबिट 2
हाँ तो
exhibit 2 now there are parallel rent receipt with respect to the same property
तो क्या कि 3 डिस्प्यूट
मिलाना क्या है यही तो है यही फाइंडिंग है।
हाँ 2010 में तो कार्बन मंडल के नाम से होगा
नाम से इशू होगा
क्योंकि हमारा 92 में म्यूटेशन हुआ तभी ना उसको सब्सट्रैक्ट करेगा।
नहीं आपका 92 में
म्यूटेशन हुआ 90 का रसीद है।
नहीं आपके पास 90 का रसीद है कार्बन मंडल के नाम से 2010 में
रसीद कटा
क्या समझे
टोटल लैंड का रसीद कार्बन मंडल के नाम से कट रहा था। खुरपानामा से उन्होंने सेटल कर दिया 2010 में।
पूरा ही सेटल किया ना
नहीं पूरा नहीं 3 दिस इज अ बिग चंक ऑफ लैंड। कार्बन मंडल के पास बहुत जमीन था।
कहां से बोलते हैं
कि हमारा डब्ल्यूएस में भी है जो
आपका जो खुरपानामा था
वो 3 डिस्प्यूट के लिए था।
was it in connection with a
portion of दिस इज ऑलवेज सेड प्लेट में भी है डब्ल्यूएस में भी है कि पोर्शन ऑफ द दक्षिण के तरफ का एक छोटा सा जगह दिया गया था टेनेंसी में। पूरा जमीन को हमको टेनेंसी नहीं दिया। इसका शेड्यूल जो दिया गया है जो डिग्री पढ़ देता है इन द डिस्ट्रिक्ट देवघर सब डिवीजन देवघर पीएस कुंदा मौजा बैजनाथपुर पोर्शन ऑफ जेबी नंबर 2 बियरिंग प्लॉट नंबर 142 कंसिस्टिंग टेनेंटेड प्रीमाइस इज 1 रूम 17 by 8 into 15 by 6 together with some land total area 1362 square feet it butted and bounded as follows north देवघर दुमका पोर्शन। और उसी के लिए उन्होंने एफिडेविट किया कि भाई हमको छोटा सा पोर्शन दिया था बाउंड्री वॉल में कुछ हुआ तो कहा कि अब हम लोग सेटल कर लिए देयरफॉर आई एफिडेविट।
अपलेट कोड का पारा 80 को खाली पढ़ना चाहिए 80 पेज इंटरनल पेज 10 It is the case of the dependent appellant that they are the owner of the suit premises. The suit premises was settled in favor of Tarachand Sharma, the father of the Parvanand Sharma, by Karu Mandal, the father of Jagannath Mandal, in the year 1936 by executing a Kurfanama, that is Exhibit B. However, the defendant have not filed any document issued between 1936 to 1992 to know so their right, title and position of the suit property. The defendant have also filed to explain as to why the land was mutated in the year in their name after 56 years of the alleged settlement. The defendant have neither filed any rent receipt of the period nor the copy of the registered to show that they were in possession of the property. A field Bujharat exercise was undertaken by the government in Devar around 1957 and 58 for the purpose of ascertaining possession of the land by people. If the defendant or their forefathers were in actual physical possession of the suit property, their name would have been entered in the government's record. It has been submitted by the defendant that in the year 1991, Jagannath Mandal has recognized and accepted the said Kurpanama by executing an affidavit before the notary public, that is Exhibit C, in which he had admitted that the suit premises was given to the father of the Parmanand Sharma and they were in peaceful possession of the same since 1936. In any view of this document cannot be relied upon because when the suit premises was already settled in favor of the father of the Parmanand Sharma in the year 1936 itself, there was no reason and occasion for Jagannath Mandal to execute an affidavit again in the year 1991. It is also important to note that such an affidavit cannot be confer any title of the suit property upon the defendants. Thus, the Kurfanama itself does not inspire any confidence and thereof. It cannot be relied upon. Similarly, Exhibit A by 1, A12 and A3 of the rent receipt exhibited D is mutation order passed by circle officials. They were it be well collected revenue record do not DW DW 1, 2, 3 and 5 of the formal witness. We have proved the rent receipt and other documents. DW4 Neera Devi is one of the defendant. In the suit, she has stated in the deposition that her husband was owner of the suit property and they are living it since the year 1936. ये कह रही कि उसी प्रॉपर्टी में 1936 में रह रहे हैं. She has admitted in his assumption that she does not pay any municipal tax and she also does not have any document relating to the suit property between 1936 and 1952. DW5 Bhairav Prasad has proved the Kurfanama, but he stated in para 13 of the exemption is chief that the Tarachand Sharma was known to him and he used to visit him in his rented house situated at the village of Rajdatpur. Neera Devi is this word defendant. He कह रहे कि 1936 my father-in-law 36 से ही रह रहे हैं उसी प्लॉट पे और ये जो प्रूव करते हैं उनका भी है वो कहते हैं कि नहीं वो क्या किराए का मकान में जाते थे. And now para 20. The defendant also submitted that the signature of Parmanand Sharma on the registered list deed is forged and fabricated. However, during the trial of the suit, the defendant did not take any step to challenge the authenticity and genuineness of the said documents. The documents was never sent to a handwriting expert to verify the signature of Parmanand Sharma. Therefore, the defendant cannot question the genuineness of signature of the system.
यही बोलना है कि ये सारा फाइंडिंग जो कोर्ट दिया है पारा 17 खाली देख लीजिए. Thus, on the basis of oral and documentary evidence and on record, I am of the opinion that the plaintiff respondent has been able to prove the landlord-tenant relationship between the parties. It has been proved that Parmanand Sharma has taken a sum of premises on rent of Jagannath Sharma and was paying rent to him at the rate of 250 per month. It has also been proved that these dependent appellants have defaulted in payment of 2010 and recovered the sum from so and so. And thereafter, para 18 only considered the defendant's case was considered only after the court come to the conclusion that plaintiff is entitled to all the reliefs.
और वो जो कुर्फा है इनका कुर्फा में क्या
तो कोई ग्राउंड इसलिए नहीं है क्योंकि डिफॉल्ट तो एडमिटेड
हम
इंपॉर्टेंट है
क्लियर
लैंडलॉर्ड टेनेंट रिलेशनशिप.
बस दैट इज एक ही क्वेश्चन है.
लैंडलॉर्ड टेनेंट रिलेशनशिप अगर आप क्वेश्चन कर रहे हैं तो पेमेंट और डिफॉल्ट इसका कोई मतलब ही नहीं होता बिकॉज़ यू विल सिंपली से दैट आई हैव नेवर पेड रेंट.
हम उस पर नहीं जा रहे हैं. हम ये जा रहे हैं कि पहले कोर्ट होल्ड कर दिया कि हम लैंडलॉर्ड टेनेंट हैं और उसके बाद हम डिफॉल्ट किया है और फिर पर्सनल नेसेसिटी है तब कोर्ट जो है हमारा एविडेंस को कंसीडर कर.
इनका कुर्फा में कोई लैंड नहीं. कितना दिन को कुर्फा दिया गया कोई इसमें डिस्क्रिप्शन है कितना 1 कट्टा 2 कट्टा 3 कट्टा. देयर इज नो डिस्क्रिप्शन ऑफ लैंड.
was the learned counsel secretary of the parties. This appeal has been filed against the judgment dated 18th of August of 2017, deeply signed on 26th August 2017, and it was passed by the district judge, governed by Jaipur, at 2022, confirming the judgment of the trial court dated 29/9/2015, giving that decree signed on 8/10/2015 by the then reviving civil judge in the civil division of Law they that is number 2 of 2011, whereby the suit filed by the plaintiffs seeking eviction of defendant on ground of default in payment of rent and personal necessity भी डिक्री किया है दोनों पार्टी and on personal necessity has been decreed. The defendants are the appellants before this court against concurring findings of the courts. This appeal was admitted for final hearing by order dated 21/6/2018 on following substantial motions. This report having the substantial motion. The counsel for the appellant by referring to the lease deed dated 8/9/1989 1 has submitted that admittedly the lease deed was an unregistered document and the same was alleged to have been entered into between Jagannath Mandal, son of Karu Mandal, and Pannanan Sharma, son of Tarachand Sharma, who at the time of filing of the suit had expired. And the same lease deed was proved by PW3, Vinod Mandal, an advocate clerk. He has referred to the evidence of PW3 to submit that PW3 had stated that notary public before whom the lease deed was executed was alive, but notary public did not appear before the court to depose. He has also submitted that PW3 had stated in his evidence on 9/9/2012 that he was 40 years of age, and since the lease deed was dated 8/9/1989, he would have been only 17 years of age. The learned counsel has submitted that his deposition does not reveal that he was working as an advocate clerk on the date of execution of the lease deed, though he had deposed that all the persons had signed before him. The learned counsel has submitted that the evidence of PW3 is highly unreliable and therefore the substantial question of law number 1 is fit to be answered in favor of the applicant, and it may be held that no reliance can be. It may be held that unregistered lease deed dated 8/9/1989, within brackets 1, was not duly proved, and no findings could have been recorded by referring to the lease deed dated 8/9/1989. However, during the course of arguments, it transpired that Exhibit 1 was marked without any objection from the side of the defendants, and further, the PW3 had deposed that all the persons had signed in his presence, but there has been no cross-examination of PW3 on the enforcing court. The learned counsel has further submitted that it was throughout the case of the defendants that the lease deed was forged and fabricated, but the plaintiff did not take any steps for the purposes of getting the signature of Parmanand Sharma examined through an handwriting expert. He has submitted that this takes into the second substantial question of law, and he submits that the learned your appellate court has gravely erred in law by shifting the onus of proving the unregistered deed of lease dated 8/9/1989 upon the defendants. And such a approach of the learned court was erroneous in view of the second proposition that the plaintiff has to stand on his own legs, and plaintiff cannot derive any benefit from the weakness of the defendant's case. The learned counsel submits that the defendants were claiming title over the property by virtue of Kurfanama, which was executed by late Karu Mandal way back in the year 1926, and plaintiffs were claiming title on their own rights, and therefore the finding of the relationship of learned or relationship of landlord and tenant between the parties based on the unregistered lease deed dated 8/9/1989 is perverse. If both the aforesaid substantial questions of law are answered in favor of the applicant, then the natural consequence would be that the finding of landlord-tenant relationship between the parties would be set aside, and the decree passed by both the courts will be fit to be set aside. Yeah. The learned counsel has relied upon a judgment passed by the Supreme Court before hearing bracket 2008 bracket close 8 SCC 564 to submit that the terms and conditions of an unregistered lease deed cannot be looked into even for determining the status of both the parties, and therefore the lease deed could not have been relied upon to hold that there was a relationship of landlord and tenant between the parties. The learned counsel appearing on behalf and has referred to paragraph 29 of the section. 29, 26, 27 together.
27 onwards.
ऑनवर्ड मतलब क्या है? 50 पैराग्राफ
30 तक 20 से 30 50 तक का नहीं है, 30 तक का नहीं है बस।
बताइए ना कौन सा
27 to 30
ऐसे होता है?
उतना ही तक पढ़ते हैं, इसलिए उतनी तक नहीं।
पैराग्राफ 27 Well, when it comes to grading on behalf of the respondents on the other hand, has opposed the prayer and has submitted that the judgments passed by both the courts has not only relied upon the lease deed, though they are for considering the landlord-tenant relationship, though both the courts have recorded that the same is being an unregistered document to be looked into for co-lacking purposes. But both the courts have also relied upon the evidence of the defendants themselves, particularly the evidence of the 5, who had deposed that he used to visit Parmanand Sharma in his rented premises at village Badnath. The learned council has submitted that though the terms and conditions of the lease deed cannot be taken into consideration, but the lease deed was enough for the learned courts have rightly relies upon the lease deed to record a finding of landlord-tenant relationship in addition to the evidence of the level 5. The learned council has also referred to paragraph 18 of the appellate court's judgment and has submitted that though the defendants have claimed that they were in possession of the property since 1936 on the basis of unregistered profana, but no document was filed by the defendants in connection with the property for the intervening period right from 1936 to 1992 to show their right title interest and possession over this property, nor a copy of the registered deed was shown to show that they had any right over this property. The learned council submits that the Kufanama, the learned appellate court by reason order has recorded that the Kufanama itself did not inspire confidence and therefore it could not be relied upon. The learned council for the respondents has also submitted that the plaintiffs had also filed rent receipt issued in the name of Kadamanda in the year 2010. The council has further submitted that the exhibit 1 was duly proved by PW3 and therefore it was for the defendants to take appropriate steps for the purposes of getting the signature of Varmana and Sharma examined through handwriting expert by producing admitted signature of Permanent Sharma. Decided that wife of Permanent Sharma was examined before the court as DW4, who deposed that इसमें लिखा है कि वो अंग्रेजी में who deposed in paragraph 8 of an evidence that Permanent Sharma always used to put his signature in English and was having passbook and other documents which contained the signature of Permanent Sharma in English, but no such document was produced before the court. He says that the defendants had alleged that the lease deed was forged, and therefore it was for them to prove that, to take steps to prove that the signature of Permanent Sharma on the lease deed was forged. But no such steps were taken. The Learned Council submits that irrespective of the lease deed, the evidence of level 5 has been taken into consideration to hold that there was relationship of landlord and tenant, and therefore the improved judgments do not call for any improvements. After hearing the Legal Counsel appealing on behalf of the parties, this court finds that the suit was filed by the plaintiffs seeking eviction on ground of default in payment of rent and also personal necessity. And it was a specific case of the plaintiffs that the cause of action arose on 1/9/2010 when the defendants stopped payment of rent since July 2010. It was a specific case of the plaintiffs that the property was given by lease dated 8/9/1989, executed between Jagannath Mandal, son of Kalu Mandal, and Permanent Sharma, son of Tarajan Sharma, and admitted from the date of filing of the suit, both Jagannath Mandal and Permanent Sharma had expired. It was the further case of the plaintiff that the property was leased out at the rate of rupees 250 per month for a period of 11 months, and admittedly the lease deed was not registered. It was also the case of the plaintiff that at the time of execution of the lease deed, an advance amount of rupees 11,000 was paid, and consequently the same was adjusted against the rent, which, and the adjustment was over by April 2004, and thereafter Permanent Sharma used to give rent at the rate of rupees 250 per month, who continued to pay rent in June 2010 and In the year 2010, after the death of Colonel Sharma, the defendant stopped paying rent to the plaintiffs. The defendants contested the suit by denying the relationship of landlord and tenant, and it was their specific case that they were in possession of the property by virtue of a Kufanama executed by Kalu Mandal way back in the year 1936, and it was a further case that the execution of Kufanama was duly admitted by Raman Sharma in his affidavit, which was marked Exhibit C, and on the basis of Exhibit C, there was mutation in the paper by Exhibit D dated 31 in 1992, and consequently rent receipts were also issued by the state as Exhibit A, A by 2. The title being the following issues for consideration, and one of the issues was as to whether there is a relationship of landlord and tenant between the parties. The issue number 3, 4, 5, 6, and 7 were taken up together, and the title considered the materials on record and the release date dated 8/9/1989, which was marked exhibit without any objection from the side of the defendants. And was exhibited by the 3. The Learned High Court also considered the fact that the ministry was unregistered document and recorded the admitted fact that the property was recorded in the name, was admittedly recorded in the name of Kalu Mandal, the ancestors of the plaintiffs. The learned tribe could also consider that the lease could be considered for bilateral purposes, and the learned tribe could also consider the fact that PW4, the wife of Raman Sharma, had deposed during cross-examination that Raman Sharma is the signature in English, and there are various documents executed by him in English, including bank documents, but none of such documents were produced before the court. The learned tribe recorded that the defendants had not produced any documents with regard to possession right from the year 1936 to 1949 and then up till 1990. The learned tribe court also considered the evidence of the file, and on the basis of evidence of the file, the learned tribe court recorded that it was DW5 recorded that it was the evidence of the own witness of the defendants in the DW5 that he used to visit. ताराचंद कुमार कौन है? ताराचंद कुमार
शर्मा होगा, फादर ऑफ द डिफेंडेंट.
ताराचंद कुमार, the father of the defendant, at his tenanted premises at Basman, and the trial observed that the evidence of the fight revealed that the plaintiffs were the tenant, the defendants were the tenant under the plaintiff. The appellate court also considered the evidence on record and held that the Turfanama did not inspire confidence and also discussed the evidence of DW5. Though he proved the Turfanama, but at the same time, he stated that Baratin Sharma was living in a rented house. This court finds that so far as the first substantial question of law is concerned, it is nothing dispute that the lease dated 8/9/1989 was produced and marked as Exhibit 1 and was proved by Exhibit 3, and the sale was taken was executed without scientific evidence. It is this book also finds that Exhibit 3 has specifically disclosed that the signatories had put their signature on the listing in his presence, and there is nothing in the cross-examination of the to doubt or question the evidence of the this book further finds that both the courts have referred to the unregistered listing and have and the opinion that it should be relied for the purpose for both active purposes, and have not relied upon the clause of the lease deed as such to bring any finding with regards to the period of tenancy, etc. This court also finds that that both the courts have not based their findings solely on the basis of the lease deed. Rather, the evidence of DW5 has been relied upon by both the courts, and both the courts have recorded that DW5 had proposed that there was a relationship that Tarak and Sharma was living in a tenanted premises. This court is of the view that the includes that apart from the leasing, there were other materials on record for the courts to come to finding regarding landlord-tenant relationship. And since the defendants were claiming title over the property by virtue of Kufanama, there was a question of any, there was no doubt regarding non-payment of rent by the defendants to the plaintiffs. In view of the nature of evidence based on record, this court is of the view that the evidence of PW3 was proved unregistered listed dated 8/9/1989 may not be said to be doubtful or questionable. Accordingly, the substantial question of law number 1 is answered in favor of the respondents and against the opponents. So far as the substantial question of law number 2 is concerned, this court finds that PW3 had proved the unregistered listing dated 8/9/1989 who reports that the parties had put their signature in his presence. The defendants had alleged that the listing was forged and fabricated. The wife of Rambanan Sharma had proposed before the court and had stated that Rambanan Sharma used to put signature in English in various documents, including banking documents, but did not exhibit any document before the court. This court finds that the learned court has taken into account this aspect of the matter and no admitted signatures of Rambanan Sharma were placed before the court for comparison. This court finds that the first question of law having been answered in favor of the respondent, it cannot be said that the plaintiff failed to stand on his own legs and any benefit has been given to the plaintiff from the weakness of the case of the defense. Consequently, the second substantial question of law is also answered against the appellant and in favor of the respondent. So far as the judgment relied upon by the appellant in practice to the 65-64 is concerned, the subject matter of consideration in the same case was clause number 9, which is quoted in paragraph 13 of the same judgment in the following manner. The Honorable Court, the Honorable Supreme Court in paragraph 29 has framed the question as to what would be the meaning of collateral purpose and then ascertain whether clause 9 of the new agreement could be moved into collateral purpose And in paragraph 30, a reference has been made to the earlier judgment. A reference has been made to the judgment of Honorable Kolkata High Court in AIR 1922 CAL 82. Wherein it was held that a document which is compulsorily registrable would not be used for collateral purpose. And the question as to who is the tenant and on what terms he has been created a tenant are not collateral facts, but are important terms of the contract of tenancy. They cannot be proved by admission of an unregistered leasing into evidence. In paragraph 34 of the aforesaid judgment, the principles of law has been written as under, and the Honorable Supreme Court in paragraph 35 has referred to the and has held that the particular clause in the lease agreement in question could not be said to be a collateral purpose. And clause 9 of the agreement could not be looked into for alleging violation of the lease agreement. Paragraph 35 of the aforesaid judgment is also given as under. This court finds that in the present case, not only the relationship of landlord and tenant has been held not only on the basis of the unregistered lease deed, but considering the other evidences on the record and in case of unregistered lease deed. कहाँ है वो जजमेंट नहीं लिखा है unregistered lease deed में जो होता है कि landlord tenant relationship का examine हो सकता है but not the conditions of lease. आपको तो पता है उनको तो नहीं पता उनको शिकायत
ठीक है
आपको तो पता है ना
नहीं इस पे हम नहीं किया
हम डाल देंगे
ठीक है
This court finds that the judgment of the Honorable Supreme Court was specifically in relation to reliance on clause 9 of the agreement. And in the present case, no clause of the agreement as such has been relied upon. Rather, it is the relationship of landlord and tenant which has been considered based on the agreement's existence. Both the versions of law have been answered in favor of the respondents and against the applicant. There is no merit.
correct
For orders at 9, second appeal 260 of 2016.
What does it mean? Are you able to find it? Maybe it won't find it. Maybe it doesn't find it. This one. Who is on number three?
I'm responding. I just received an instruction on behalf of Mr. Kaushik sir that it may be fixed for next day. Archana.
Where is the applicant? Nobody appears on behalf of the applicant. Council for, you are appealing for responding number?
I'm not getting the file or something. Mr. Kaushik,
After
Himanshu,
Mr.
Himanshu,
Himanshu Bans.
Hers.
Advocate submits that he has been instructed by Mr. Kaushik Sathi to appeal in this case on behalf of the respondent, but he is not aware as to which respondent is represented. Since the applicant is absent, we put this case on 13th of June.
Attempt second appeal 264 of 2016.
There are two IE.
Are you?
IE number for the substitution of legal years of respondent number 19 G man. That is sometime in the month of December 2024.
19B.
G man. The description of the legal years of 19 G has been mentioned in para 6 of IE. IE number 2899 of 2025.
When did you die?
As reported by the process server member, she died in the month of December 2024.
2024?
Month.
What are the names of legal years?
Legal years, the name of the legal years have been mentioned in para 6 of the argument 19G. Nikki Chaurasia and Vicky Chaurasia, both son of late Gito.
Wait, double nine.
Wait,
Para number
para number 6.
I am double nine of 2025 in its number 264 of 2016. The Gannett Council for Happiness has submitted that this interpretive application is not filed for substitution of respondent number 19 with effect G, which is said to have expired in the month of December 2024. So he said that the name of legal years and officers has been mentioned in paragraph 6 of the agency application. We should focus to the proposed legal years and successors of respondent number 19 with effect G, which details under ordinary process in the interpretive application to be filed within the period of 10 days. Both this period of 13th of June are within the
One of the another IE also is for the substituted service of notice. And order 5 to 20. One of the against respondent number 5 to 7, 17D and 18D. That is IE number 2901 of 2025.
of 2025.
Substituted service of respondent number.
The respondent number 527, 17D and 18D. So they are avoiding service of notice and due to that it is not possible.
They are residing at the same place.
The address is given at
Address is correct.
address is correct. I have mentioned at para 13.
I am number 2901 of 5 years in East India, 264 the learned as submitted that the response number 57, 17D and 18D are avoiding service of notice and therefore distribution has been filed seeking substituted service. Let this notice be issued. He has also submitted that the address of the posted respondents have been mentioned in paragraph number 13 of the integrated application, which is the same address at which the notices were sent. The respondent numbers 5 to 7 are residents of district Koyama and 17D is of Hazarika and 18D is of Chhattisgarh. The details mentioned in paragraph 13 is as follows. Notice be issued upon the posted respondents to the concerned police station for which they will be fined before the store within a period of 10 days. 13.1.
Through the officer in charge.
Yes.
Then I have to only submit the requisite.
आप खाली अपना आइए उसका डिटेल से अपना फाइल करें एडमिटेड से
Admitted.
एडमिटेड से बिना क्लिक क्या जाता है और ये आइए तो कॉपी फाइल कर दूँगा on the eligibility application and memo
Memo.
appeal
Appeal.
second appeal का notice खाली फॉर्म जाता है
क्यों फॉर्म ठीक क्यों जाता है
in the prescribed form
Right.
in the prescribed form along with the copy of the
I
हालांकि जैसे नहीं
within 2 weeks
दो हफ्ता चीज
दो हफ्ता दोनों में कर
दो हफ्ता तेरह जून को आएगा notice will be served through the concerned police station.
Item 11/7/22 of 2017.
This is the admitted second appeal, Lordship. Notices were issued to the respondent number 1 to 39. May kindly see office notes, Lordship. The notice of respondent number 1 to 3 received by daughter-in-law.
क्या partitions होते हैं?
हाँ, partitions होते हैं.
Partitions होते हैं तो उन्हीं को serve करना है.
In notice of the in notice of
Grant
this
के proof ही नहीं होगा, grandson के proof ही नहीं होगा.
सन को तो माना जा सकता
हाँ,
है. सन को तो माना जा सकता है.
क्या पता किस तरह का dispute है. बाप बेटा आपस में लड़ रहा होगा तो कौन किसका वकील दे देगा? बताइए. कोई भी appeal हुआ ऐसे? Brother-in-law, uncle.
Grandson, nephew, respondent number 7 note found. तो phrase हम कर देंगे. Present and correct address में.
Yes, number 22 of 2017. Council for Daphne, praise for time from time. Praise for and is granted 2 weeks time to take fresh steps upon respondent number 7 at his present and current address.
And 31 also lost.
7 and 31
31.
at their present inheritance.
Lots.
Under ordinary process.
Lots.
Not done right.
Okay.
The appropriate order with regard to service of notice in concerning other respondents will be passed on the basis.
Lots.
ये 32 में 55 भी कर दीजिए. ये कोई सुधीर कुमार नहीं तो कौन है? इनके ऊपर भी कर दीजिए.
इसको भी कर दो.
एक सेकंड. कौन से हुए 7
31.
ठीक है?
जी.
ये वो भी.
Item 12, second appeal 74 of 2019.
The sole respondent died for which substitution has been filed.
On the last occasion, I had informed the court, my lord, that the sole respondent had died. Lordship, pursuant thereto, my lord had instructed them to take instruction, my lord, and thereafter they have filed an IM. Kindly take the last order. Yeah, my lord, since my lord, my wakalatnama has not reached, my lord, therefore, lord, the notices has to go upon the deceased.
IA number 2383 of 25 and AC number 73 of 2019. Also for the winner for something that the school respondent had expired on 12/5/2023.
22 ladies. 22.
आपका देखिए ना क्या लिखा होता है डेथ सर्टिफिकेट. डेट ऑफ डेथ. It refers to the death certificate annexed along with the individual application. लिखा है कि नहीं लिखा है?
22/5/2023.
हाँ, 22/5/2023.
Yes.
हाँ.
12. नहीं आप 12 बोलिए.
The names of the legal heirs and successors of the sole respondent has been mentioned in para number
6 ladies.
para number 6. Well, when it comes to appearing on who had filed wakalatnama on behalf of the deceased respondent, on behalf of the sole respondents since deceased, submits that he has no instructions in the let notice be issued to the legal heirs and successors of the sole respondent under ordinary process for which requisites be filed by the applicant within a period of 10 days from today. A notice is if IA में जाएगा, IA number 2383 of post on 13 June of 2016.
Item 13, second appeal 118 of 2020.
Internet application 264 of 25 for substitution of applicant number 25 Mamta Bibi.
Applicant number 25 is there.
Yes.
The legal who's for the respondent
It is before admission.
before admission. How many respondents are there?
Several new songs.
Without hearing the respondents, the subject refused to hear them. Yes, Mr. Das.
There's also delay of about 6 days, 7 days. So,
It's right. We have to issue notice to representatives.
yes.
IA number
264 of 25.
264 of 2025. Then it comes for the applicant has submitted that applicant number 25 has expired there is a delay in filing substitution petition. The details of the creditors have been given in the eligibility application and the Palatana already have an also been filed. There was something that the secretary has not been completed so far. Issue notice to the respondents
Yes, 30 respondents.
in ID number 264 of 1985 under alternative process for which refusal to file by the applicant within 1 month
2 weeks.
within a period of 4 weeks. From this case number 230,
Item 14, second appeal 25 of 2023.
this is applicant.
In addition to I has been filed one for the substitution and one for the additional evidence.
Who is for the, this is second appeal.
Yes,
Additional evidence in second appeal.
yes, Your Lordship. And first is 3232 for substitution petition.
Applicant number 7.
Yes,
Where
17/1/2011.
where is the Vakal now? For the legal years.
That we have to find.
As essay number 25 of 2020. The learned counsel for document assemblies that petition seeking substitution of applicant number 7 has been filed. ID number 3233 of 2025.
File number 4, Your Lordship.
She submits that we shall seek instructions and find the Palatana on behalf of the proposed legal years and successors to applicant number 7. Post of 13.
Item 15, first appeal 319 of 2023. Item 15.
2 दिन का डिले है लिमिटेशन आइए नंबर नोटिस जाए
Second number 319 of ID number 2594 of 2025. This petition has been filed for accommodation of delay of details in filing. Yet notice be issued and interlocutory application as well as in the first
लो
for which refusal to be filed by the applicant within
2 weeks
notice एक sole respondent है
अच्छा एक ही है
within a period of 10 days from today
ठीक
and the ordinary process. Hold this case on 13
Item 16, first appeal 326 of 2023.
So there is an IA for condoning the delay of 189 days in addition.
Sorry,
There is an IA for condoning the delay of 189 days in addition.
I mean
6507. Sorry, Lordship 6570.
ID number 6570 of 22 and essay number 326 of 2023.
Yes.
Council for the applicant has submitted that there is a delay of 189 days in fulfilling the subsidy and according to the interlocutory application of the rights and operation of the issue notice to the respondents on the interlocutory application as well as in the main appeal for which requisites and the document process being filed within a period of 10 days.
2 weeks. Okay, 10 days sufficient in addition.
10 days. Suppose this case on 13 June 2017.
Much
Ordinary process services. बाहर जाने का क्या कोई भी झारखंड के बाहर गवर्नमेंट प्रोसेस नहीं करते हैं।
फाइल मेडिसिन बाहर के भी
नहीं।
है टाटा एआईजी कंपनी है
टाटा एआईजी की स्टैंडिंग काउंसिल हो गई यहाँ पे।
और उनके वो ब्रांच मैनेजर्स को भी
महाराष्ट्र
जी
वेस्ट बंगाल, ऐसा करेंगे 1 to 8 ठीक है अंडर स्पीड पोस्ट ठीक है ऑफिस टू ट्रैक स्पीड पोस्ट 9 and 10 को ऑर्डिनरी ठीक है।
Item 17, first appeal 13 of 2024.
Your Lordship, earlier occasion notices were issued to the respondent, and as per the report, respondent number 8, 9 and 15 has already died, Your Lordship.
Council for the as per service report respondent number 8, 9 and 14 have been started.
Because I'm appearing for respondent number 1, 2 and 3. I was on KVT, I appeared on the last
Council
occasion.
for the respondent number 1, 2 and 3 is present.
Pending for 4, 5, 6, 7, 10, 11, 12, 13, 14 and 16.
And I think all except the one who have minimized matters.
Other respondents are appearing before us,
Yes.
correct?
Yes.
Council for the applicant, praise for some time.
3 weeks time, Your Lordship.
Praise for 3 weeks time to take applications. Hold this case on 16th of April.
16th.
April.
Item 18, first appeal 68 of 2024.
Limitation of 618 days. I will have a combination that number 2330 control.
I am days. In filing the first who are the respondents? Respondents and ordinary process in the first appeal as well as the for dismissals we file ordinary process within a period of 2 weeks. Post conversion approved.
Item 19, first appeal 72 of 2024.
Same prayer, same days, 618 days. IA number will change.
IA number is
329.
2329 of 2025 and FA number 72 of 24. This may be
618.
618 days. और same सारे respondents झारखंड के हैं.
Yes, Lordship, Ramgarh के यहाँ से.
Item 20, first appeal 240 of 2024.
For the short time for filing rejoined and to the rejoined to what? Counter the petitioner
Counter file के
IA
limitation
But
में time पे
my limitation is for 365 days, 465 days in filing the first appeal. And the notice
appeal number 240 of 2024 with ID number 11418 of 2024. Also for the appellant, grace for time to file a rejoinder to the counter affidavit filed by the respondents with respect to petition of आगे में कितना आपको बहस करना है?
then I वही चीज तो बता रहे हैं विदेश
वही चीज तो हम भी सोच रहे हैं
हमको कुछ इसमें हम लोग लिखे व्हाटएवर आवर 13 जून उन लोग लिख दिए हैं कि इनको मालूम यही उनका कहना है